Sanskar, can we begin?
I think we can go ahead. Yeah.
So, sir, I'll just do a quick introduction and then we can begin.
Sure.
Good evening, everyone. Thank you for joining. Sorry, my video. Good evening, everyone. Thank you for joining us today. For those of you joining us for the first time, the Nyaya Forum is a student in Nalsar, which looks to promote careers in courtrooms, that is both as litigating lawyers and as judges. And during this lockdown, we started this webinar series to complement our classroom learning and help us develop certain practical skills that we could apply as litigators. One point on housekeeping before we begin. We will be taking a couple of questions towards the end. So I request all of you who have questions to put it into your Q&A tab at the bottom of your screen so that we don't wait for questions to come in right at the end. With that, it is my great privilege to introduce our speaker for today, Mr. Nakul Dewan, who is a senior advocate at the Supreme Court of India and a barrister at 20 Essex Street. Mr. Dewan, before moving into independent practice the second time around, was with Allen and Gledhill in Singapore. The topic for today's lecture is litigation strategies in cross-border disputes, a subject that he has considerable experience with, and I believe also teaches quite regularly. So without further ado, so we look forward to your lecture and thank you for joining us today.
Thank you, Siddharth, and thank you to everybody at Nyaya for inviting me and for the students at Nalsar. I'm not very certain about the demographic mix of the people who are listening to this, but I assume it's a mix of students and perhaps some young practitioners. When Siddharth spoke to me maybe 2 or 3 weeks ago about setting out a topic for a lecture, and we came about this topic, which is set out as litigation strategies in cross-border disputes, I actually thought I would be able to borrow a lot of stuff from what I teach at the National University of Singapore, put it all into one lecture and give it to you. When I started working on this over the weekend, I realized that I had to throw all of that away because I had to think afresh for this lecture. One primary reason for that is that unlike other lectures which I give, and unlike an arbitration practicum which I conducted a couple of weeks ago, nobody here has any reading material. So nobody has read up anything that I would probably need you to have read before you attend a lecture or a class. So I pretty much have to do this like in a seminar series, like I'm talking to all of you, with the basic understanding that most of you would understand a little bit of law. You could be first-year students, you could be fifth-year lawyers, but this lecture is tailored for everybody. I'm going to begin with a theme, and I'm going to try and make sure that by the end of that lecture, that theme works itself out, and you're able to understand where I'm coming from. And the reason for that is this. If there is no cogency to what I tell you, you're pretty much going to be left after this lecture wondering what I've spoken about. Well, here's the cogency I begin with. Litigation strategies in cross-border disputes is all about smart lawyering. It's also about ethical lawyering. So everything that I tell you across and through this lecture will require you to think as a smart litigator, but also as an ethical litigator. It's not about taking shortcuts. It's not about setting things out in, in the middle of a lecture. It's about smart lawyering and being ethical lawyers. Okay, so it's about thinking smart, but thinking ethically. It involves you to remember that you have professional obligations and you have professional ethics which bind you. And every time you think of a smart lawyering move, you have to bear that in mind. Now, what's my starting point? My starting point is, what is a cross-border dispute? You can have two kinds of cross-border disputes broadly. One could be commercial and the other could be non-commercial. Non-commercial cross-border disputes relate to family law matters, matrimonial matters. But that's not going to be the focus of my lecture. The focus of my lecture is going to be commercial matters, and commercial matters typically emanate from a contract. And the reason why that is important for you to understand is because contractual disputes are normally decided in terms of a dispute resolution mechanism that is chosen between the parties. So if you had a civil dispute, a land dispute, a partition suit, you wouldn't choose the court, you wouldn't choose the law, because all of that would come within the civil law procedure of a state. If you had a criminal issue, well, the law would go after you, but that would be the law of the state. So you would never have the Bombay High Court deciding a Hyderabad criminal case, or the Delhi High Court looking into a partition suit which is arisen in Chennai. But that does not happen when you're dealing with contractual disputes. And that's where I make my first point. And the first point is, when you have the right to choose a dispute resolution mechanism in a contractual dispute, especially when you're looking at cross-border disputes, then at the first port of call, you are making a strategic decision. How that dispute is going to be fought, where that dispute is going to be fought, and the manner by which, and the rules that would apply to that dispute. What's the least favorite in cross-border disputes? Well, national courts. No party typically wants to agree to the national court of the counterparty being the court where the dispute is going to be adjudicated. What's the most favorite? I think records will tell you that it's international commercial arbitration. It gives you a neutral forum, it gives you neutral arbitrators, and it gives you a choice of law. Extremely important when you are thinking about disputes. What is getting to be favorable? Well, international commercial courts. The English court is considered an international commercial court, and you see a lot of disputes that are adjudicated there by the consent of parties. The Singapore International Commercial Court has become a relevant commercial court in Asia, which has now started looking into a number of disputes where parties have opted. What goes behind opting for these courts as opposed to arbitration? Well, very often parties have to make a choice. Do they want a system which permits an appeal? Well, then they choose a court. On the other hand, do they want a system which is more which leads to a more enforceable award? Well, then you end up with arbitration. And the reason for that is because the New York Convention has been signed by significantly more countries as compared to the Hague Convention for enforcement of foreign judgments. These are strategic issues and points that you need to bear in mind at the very stage when a party you're acting for is looking at entering into a cross-border contract. And don't think as dispute lawyers, you won't have to deal with it. Very often, if you're working in a law firm, your commercial partners will walk up to you and tell you, what do we do with this dispute resolution clause? What do you think is the best thing for us to do? And you look into the kind of contract that you have and you advise. That's the first part of litigation strategies for cross-border litigation. But let's now move on to what we really wanted to talk about. And that is, how do you strategize a dispute once it has arisen? Now, the reason why this becomes very hard for me to do over a lecture without any reading material is because I'm literally talking in the abstract. And I have tried to bring some cogencies, like I mentioned, to what I'm going to talk to you about. Let's look at it from a litigator's perspective. What is the most fundamental aspect that a litigator needs to bear in mind? Well, to win for the party that the litigator is representing. Does it necessarily mean getting 100% of the claim allowed if you're acting for a claimant, or 100% of the claim dismissed if you're acting for a defendant? No, it doesn't. I mean, very often claimants will file claims where they necessarily know that they're entitled to 80 cents to a dollar. Very often you'd be asked to defend a case where you know that the party you're representing is perfectly happy paying 80 cents to a dollar. How do you strategize that litigation to get what your client wants? One could well be through litigation. The other could be through a settlement. And the question that you have to ask yourself as a litigator is how you're going to achieve that victory for your client. If you look at the statistics that you have in the United States of America, you would realize that pretty much only 2 or 3 cases go to trial out of 100 cases that are filed. And the reason for that is because they arrive at a settlement. That is often done through litigation strategies that are employed when those disputes are being adjudicated. And what you need to bear in mind when you're looking at cross-border disputes is how you're going to get there. And I'm going to talk to you, taking you through the cycle of a dispute and focusing on 4 points on where you can effectively deploy strategies to be able to achieve the result that you want. You have to remember that in cross-border disputes, very unlike, say, the Indian scenario, you can end up in a situation where you will have an effective decision-making within a time-bound period. When you're looking at Indian court litigation, very unfortunately, with the backlog that we have, sometimes time is a little amiss. That doesn't happen when you're looking at cross-border disputes. And that is what then makes you decide and work on strategies so that you can try and get your clients the relief that they want. How do you go through a dispute? Well, very simply, you file a statement of case. You then end up with a statement of defense. In the middle, you probably have an injunction application. You then have an evidentiary stage, which includes a procedure called disclosure of documents. You then have the evidence. You then have the trial where the cross-examination takes place, and then you have arguments. Now, at each point of time, you can employ a litigation strategy. I don't think I have the time to take you through a litigation strategy for each of the points that I've set out. But like I mentioned, I will deal with it in under 4 points. And the 4 points that I'm going to talk to you about are strategies in relation to injunctions, strategies in relation to disclosures, strategies in relation to evidence, and 4, something that is necessary in a cross-border dispute, strategies in relation to choice of law, which can play itself out at any of these stages that I have given them. Let's now look at injunctions. Now, when you look at it from a claimant's perspective, what does an injunction do? Well, it gets you a restraint in relation to disposal of assets, a restraint in relation to disposal of money, and if you're very lucky and the facts let you do it, a deposit of the decretal amount in something that in India we call an attachment before judgment. How do you employ that strategy in a cross-border dispute? And should you employ that strategy in a cross-border dispute? Well, at the first port of call, the answer is if the facts give you the case to make out for an interim injunction, you do it. But also remember that injunctions have a limited lifespan. You're not dealing with an injunction that you get and you could potentially get in a domestic court where they could carry on for years and years and years. At the end of which, if you lose the case or the injunction gets vacated, all you have ended up doing is causing the counterparty a lot of harm with absolutely no pain to yourself. Well, in a cross-border litigation, that will not happen. If you went to, say, the court in England, you went to, say, the court in Singapore, if you got an injunction, you would get it with an undertaking as to damages. And that is extremely critical to remember. Because if it is later found that the injunction ought never have been granted, that it has to be vacated, or if you were to lose the case eventually, you would then be bound to pay the counterparty a lot of damages, damages to the tune of the pain and the losses that you have caused the counterparty by the injunction that you have been granted. Now, doesn't that change your litigation strategy? I mean, we all know why we love coming to an Indian court to try and get an injunction. But if somebody said that you had to give an undertaking as to damages, you need to think about how sure you are that this ex parte injunction that you get behind a counterparty's back is going to get vacated when the counterparty comes in. That is an extremely relevant point. What about a defendant? Well, if you're dealing with a litigation in India, very often defendants are very keen to try and get injunctions vacated for the simple reason that because there is no definite timeline within which it will operate. But what happens when you're outside of India? Do you immediately rush to get an injunction vacated? Well, perhaps not, because you have an undertaking as to damages. And there have been cases where the claim that you can get in terms of damages for the vacation of an injunction months and months later would turn out to be more than what you would have been able to make if no injunction had been granted. It's a completely different mindset that you need to operate with. And that mindset is based on the first point that I made. You need to know the court and the rules and the applicable law that would apply to you when you are dealing with a cross-border dispute. Now let's come to the second point. That relates to disclosure. And what is important from the disclosure's perspective? Let's look at it from the claimant's perspective. You need to try and prove your case. You need to try and you need to have documents to be able to prove that case. But what happens if you don't have those documents? Can you employ litigation strategies to try and get those documents? I'll give you a simple example. A client walks into your room and says, I was a shareholder of this company. I have been wrongfully removed. I used to have an email ID. It's got all the documents that the company has in relation that I have that are necessary in relation to this dispute. I can use those documents to show that what the company has done is wrong. I want to sue under my shareholders agreement, and I have a $100 million claim for damages for my wrongful removal. What do you do at a point of time like that? If you were to look at a domestic litigation, you would say, well, you're the claimant. You need to prove your case. If you don't have the documents, there's very little I can do. Well, not when you're looking at it internationally. Because when you're looking at it internationally, where is there a rule which prohibits you from getting documents to prove your case? There isn't one. You can actually commence proceedings and ask for disclosure of documents from the counterparty, which could well be your email records, which would show that your case can be proved. And why go that far? You can even ask for something called pre-action discovery, which gives you a basis for getting documents from the counterparty to commence your case. Now, when do you employ a strategy like this? Yes, you've had this client come up. Your clients explain the problem to you. And then the client also tells you, hey, guess what? Before they threw me out of the company, I knew they were going to do it. I actually mapped the server and took out all the relevant emails. It wasn't legal, but I have it. What do you do as a lawyer? Well, you have all the emails, you have all the ammunition. Can you act unethically by using illegally obtained evidence to be able to prove your client's case? And the answer is no, you cannot. So you deploy this strategy so that you can get documents from the other side to be able to prove your client's case. And this has happened in a case that I was doing a couple of years ago for an Indian party against a UK party, where the shareholders were thrown out, where we asked for pre-action disclosure, and the entire claim was based on documents that we received from the counterparty. And the counterparty wasn't really surprised, because as a party based in the UK, they were well expecting it, because they knew that was the only way that we would be able to prove our case. And they knew that they were under an obligation, a legal obligation, to make a truthful disclosure. Now let's look at disclosures from a defendant's perspective. What does a defendant want to do when there's an application for disclosure? Well, naturally, the defendant wants to resist disclosure. The defendant also wants to ensure that it is able to, at some level, defend the case. How does the defendant do that? Well, the defendant adopts strategies which are well-founded in law to say that it's not required to give the documents. That's typical, isn't it? But now let's take it a step further. Can the defendant apply an aggressive strategy in relation to disclosure to be able to force the claimant to effectively give up a case? And the answer to that is yes. And let me give you that straight by way of an example of a large case that I did in Singapore about 8 or 9 years ago. Okay, and this happened just in the aftermath of the global financial crisis in 2008. I'm not sure how old a lot of you were at that point of time, but the global financial crisis was probably just a notch worse than COVID-19. The entire economy of the world was down. And right in the middle of that downturned economy, there was a Singaporean gentleman who sold his company to a Middle Eastern sheikh in Dubai for a sum of $4 billion. And that company made shipyards and rig yards. And rigs. And that company had a shipyard operation in Indonesia, in a place called Batam, which is a 45-minute ferry ride away from Singapore. And it, at the time when the contracts were entered, when the deal was struck, had approximately 40 orders for ships and rigs. Now you've got to remember that those orders go into, the multi-million orders, they go into multi-million-dollar orders, and they effectively could touch up for $1 billion or so. When the Dubai-based company entered into the fray, it walked into the shipyards and said, there's a huge problem here. There's been misrepresentation of the state at which the shipyard and the rigs have been completed. And we have 40 clients waiting for deliveries, and there is absolutely no way that we would be able to meet the delivery timelines. And if we delay the delivery timelines, there will be a claim for liquidated damages that is going to come against us. And that liquidated damages claim is into the tune of about $500 million. And that's a sizable sum. So the company decided to sue the old seller for a sum of about $620 or $630 million in the Singapore High Court. This is where the old seller decided that he was going to be smart. And that smartness came out in the disclosure application. At the point of time when when disclosure applications were being filed, the seller asked for a disclosure of documents, forgetting for a moment that the claimant hadn't produced adequate documents. And he could have well argued that it was for the claimant to prove its case by asking the claimant for documents which showed delays. And the documents that was asked for were in 3 stages. 1, on the day the transaction was done. 2, on the day when the statement of claim was filed. And 3, as at the present date. And when the claimant decided that it was going to try and produce the documents, all of which were relevant and material, it had to put its hands up because it just didn't have the record. The company they had bought was in shambles. It had never maintained proper records. And even after the new claimant had taken over, record keeping took a while to get sorted out. And the claimant folded its case, saying, well, there's no way I can prove it because you've asked me for documents and I don't have it. And that case settled for a total sum of about $6 million. For the defendant, that was a massive, massive victory. And that is a litigation strategy that was deployed very, very effectively. Now let's look at the third litigation strategy. That's a matter that comes to evidence. How does that become a litigation strategy? Well, it becomes a litigation strategy when you look at it from the perspective of the techniques that you're required to deploy. Different systems have different methods for cross-examination of a witness. When you cross-examine a witness in India, there's only so much that you can do because of the technique we employ. The techniques that are employed are you ask a question, the witness answers the question, and the answer is paraphrased by either the registrar or a local commissioner or an arbitrator or a judge into writing. Now, those are not techniques you employ when you're doing cross-border litigation. Different cultures permit you to push a witness to the limit without interference by either a court or a tribunal. The American system lets you push a witness to the brink. Other common law systems allow you to effectively browbeat a witness. And when I say browbeat, well, I say it from the perspective of obviously doing it within limits, but pretty much letting the witness stay onto the question that you have asked without giving any explanations. And very, very often, those strategies make for an effective cross-examination. And that is why it's very important for you to remember the court you're appearing before or an arbitral tribunal you're appearing before to be able to assess the litigation strategy that you can use for conducting a cross-examination. But is that the only thing that you do when you're in cross-border litigation? Let me give you a very interesting example of something that happened during the witness examination stage in international arbitration I did in Singapore. And it related to North American cricketing rights for IPL. Well, witnesses landed up there. We thought we had a rock solid case. They were going to go in for cross-examination. And just from the time that they were walking in from the room where they were sitting until the arbitral hearing room, they were met by a sheriff from the court and handed over summons. What the counterparty did was to have filed another case against the witnesses. Legitimate or illegitimate, I don't know. And they got the court to issue summons. Typically, these witnesses were from outside. Summons would have had to be served in a foreign jurisdiction. They told the court that these people are coming to give evidence in Singapore. They're going to be giving evidence at so-and-so time, at so-and-so place. And the sheriff just went and said, we're complying with an order of the court and we're required to give you these summons to appear before court a week from now in a completely different case. What do you think happened to the witnesses by the time they reached the witness room? There was absolutely no way that they were in any state to give evidence. Was it ethical? Well, very, very borderline. Would I do it? Perhaps not. Unless, of course, I probably thought I had a real case against the witnesses. Did it happen to a case we did? Well, yes, we did. It did. What happened to the witnesses? Well, is another story. What happened to the case? Well, our witnesses just decided that they didn't like what happened. They were absolutely disturbed by what happened. It was an American company. They went, they finished giving evidence, went back, called up their American lawyers, declared a Chapter 11 bankruptcy in America overnight because of the time difference. We came back to the tribunal the next morning and said, sorry, there is no case. We're a company that's declared Chapter 11 bankruptcy. Thank you very much. We're walking out of these proceedings. litigation strategies both ways. At the end of the day, the strategy did not work for the counterparty. But that's really what we did have to do. Which now really gets me to the last point, and that's the choice of law. And like I mentioned when I started off, the choice of law permeates through an entire proceeding. But let me just give you one very simple example of how it's been used in the past. As you're aware, in a cross-border dispute, you have a choice of law. You don't necessarily have to choose the law of the state where performance is taking place. It could well be another law. Now, in this particular case, there was a choice of law that had been set out in the substantive contract. And this related to an arbitration that was taking place in London. But there was no choice of law set out in the arbitration agreement, because very often arbitration agreements simply set out where the dispute is going to be fought and do not talk about the law which governs the arbitration agreement. Now, if you understand conflict of laws, you would understand that there are three laws which effectively govern an arbitration case. One is the substantive law, which governs the contract. The second is the curial law, which is the lex arbitra, which governs the arbitration. But you also have a law which governs the arbitration agreement. And it's always debatable on what that law must be. Would it be the lex arbitra, or would it be the substantive law of the contract? And there's a lot of jurisprudence on that. I don't want to waste time going into that jurisprudence, because that jurisprudence would very often lean towards saying that it must be the substantive law of the contract, which would also be the law of the arbitration agreement. But you would also find cases which would take the counter view, which is that an arbitration agreement is a separable document, and it must, and if nothing is mentioned, then the law governing the arbitration agreement must be the law of the seat of the arbitration. And I don't think this is the lecture where I want to do this and go into any more detail about that. But what was done in that case by a clever defendant was the following. In a letter that was written in response to a massive claim, a line was slipped in setting out that the law governing the arbitration agreement was the law which governed the substantive contract. And the defendant agreed that the lex arbitra was English law. And the matter related to patents. And this line never ended up getting rebutted, even though there was considerable correspondence between the parties. And this sentence, by an agreement of the parties, got into the terms of reference of an arbitration. Well, at the point of time when the defense was going to be filed, a defense was taken. And the defense said, even though patent disputes are arbitrable under English law, they are not arbitrable in accordance with the law governing the arbitration agreement. And suddenly hell broke loose. And a preliminary application was heard on the tribunal's was moved on the tribunal's jurisdiction to hear patent disputes. And the claimant lost the preliminary application, and the tribunal took the view that it had no jurisdiction under the substantive law of the contract, which had then become the law of the arbitration agreement, to adjudicate patent disputes. So where does all of this leave you? I've given you 4 different examples: injunctions, disclosures, evidence, and choice of law. And all of these are the first 3 form 3 different facets of the cycle of a litigation or an arbitration. The 4th can play itself out at any point of time. All of this will lead you to where I'd like to conclude, which is by making 3 points. One, each case requires a different strategy. There is no one-stop solution or strategy that you can employ for every case. Strategies get evolved if you know your case well and you know your law well. And that will allow you to factor in every possible element. And the third one, keeping the other side on its toes and always guessing what you're going to do will always allow you to put constant pressure on the counterparty. You could either be a claimant or you could be a defendant. But if you follow these three strategies, you are going to be well within the possibility of trying to win the case for your client. And like I said, a victory doesn't necessarily have to be 100% success or 100% defeat. It could be somewhere in between. It's a question of how effectively you use the strategy, which then lets me end this lecture by coming back to where I started off. It's all about smart lawyering. And you should employ smart lawyering in a manner that is ethical and keeps you within your professional boundaries. Because that is what you are engaged for by your clients when they ask you and trust you with their litigation. On that note, I'd like to thank everybody for letting me address you on Monday early evening, and subject to any questions that might be there, I wish all of you a great day ahead and a great June, and hopefully we will all get out of COVID-19 and try and live our life as normally as we used to till a couple of months ago. Thank you.
Thank you so much, sir, for that. We've got a couple of questions. Can I put them to you?
Sure.
So the first one is...
If they're very difficult, I will put them back to you.
All right, so I don't know how well equipped I am to deal with them, but when dealing with common law governed disputes that go to arbitration, what are some of the strategies that you employ in order to admit evidence from pre-contractual negotiations in order to interpret the contract? Is there any strategic value to appointing an arbitrator from the civil law tradition who may be more willing to consider extra contractual evidence?
So the answer to the question, let me answer the second part first, is no, there isn't. Because at the end of the day, please remember that even civil law trained lawyers understand this very basic concept of contract law, under which what's set out in the contract is set out in the contract and the parole evidence rule comes into play. What are the strategies you employ to try and get evidence of intention, which may be different from what is set out in the contract? Well, there are certain legal basics for you to allow such evidence to come in. One is when the contract is not clear. Now, you can take that position and say the contract's not clear and the contract needs to be explained. That will let your evidence come in, but whether it's going to be accepted is a multi-million-dollar question. In all likelihood, it is unlikely to be accepted. The other aspect that is used sometimes is the doctrine of implied agreement, where you say it was that a particular contractual provision was implied between the parties, even though it's not set out expressly. And that's again being used as a methodology to bring such evidence in. Success of that argument, very debatable. If there's actually a gap in the contract, yes, tribunals or courts have accepted the doctrine. But really, if you're just trying to be cleverer than half, then you're going to be destroyed in a cross-examination. And let me just give that to you by way of a short example. If I was, say, cross-examining Siddharth, who I can see, on an implied agreement issue, I would first try and build a cross-examination where I would lead him to accept that it was an extremely important part of the contract. That's why there's an implied agreement. And he would have to just continue saying, Of course it is. I mean, it's extremely important. Parties understood it, so on and so forth. And once I've taken him down that garden path where he thinks that I'm completely accepting the case that he has set out, I would then just ask him a very simple question. I'd say, well, if it was so important, then why wasn't it captured in the agreement? And then he'll be like, oh, yeah, actually, listen, I've just said it's extremely important. It was part of our negotiations, then why wasn't it captured? And you don't really have an answer to that, do you? It gets very difficult, and it makes it worse if there's an entire agreement clause in place, because then that makes it tougher for you to give any explanation. But yes, that's how it's done.
Thank you, sir. Second question. In practice, how often have you seen cases in which there's an uneven playing field when it came to stages such as witness testimony or witness coaching, due to the fact that different ethical conduct rules govern opposing counsels?
So witness coaching, I think I can safely say is disallowed under any system. The extent to which you can do witness preparation perhaps differs from system to system. So the US has a slightly more robust system for witness preparation. And if you actually look at the US system for witness preparation, I think a common law lawyer in England or Singapore would be appalled, and so would a common law lawyer in India. Does it lead to something that's unfair? I don't necessarily think so. And I'll tell you why. Because at the end of the day, if you are a smart cross-examiner, you will be able to get out the truth. And if you have a unbiased tribunal or an unbiased judge, they will be able to see through a over smart answer, because they would know that it's something that the witness necessarily doesn't believe in, but it's something that the witness has been told to say.
Right, sir. So I'm going to ask you a question from your experience. Could you name one or two seniors or senior professionals who you have worked with, who've inspired the kind of strategies or taught you the most in terms of the strategies that you adopted?
Okay, so let me give you an example from a Singapore case, because it really relates to trial. And it's something which is very new to India. I've never tried it because I don't think I have the guts to try it. And it also shows you that as a litigating lawyer, you need to have a lot of guts and believe in the case that you're going to run. But there was a very senior practitioner in Singapore, a senior counsel, and I'm not taking any names, who was acting for a bank in a multi-million-dollar case. And he took the view that the bank's witness was probably a cuckoo. So if the witness got into the witness box, there would be a massive problem. Now, here's the point. I mean, everybody knows the common law principle that a claimant needs to prove its case. And the defendant really has to do nothing, right? The defendant can try and make the claimant disprove its case. So after he cross-examined the claimant's witnesses and he got everything that he wanted, and the judge said, Mr. So-and-so, would you now call upon your witness? He stood up and said, we don't have a case to answer. I don't need a witness. The claimant has no case. And that's it. And he stopped. And the judge looked at him shocked, saying, what are you up to? I mean, you've got a witness. I mean, what are we going to do? He said, I don't have a case to answer. The claimant has failed to prove its case. And parties left, came back, made submissions, and they won. The claimant's case was thrown out. That's litigation strategy. You think about it on the spot, you see how much evidence you've gotten, boom, employ it. So that is, it's a strategy which tells you that if you're certain about your case, you can be bold. But you've got to be sure. So that is one example.
I think we'll take one last question, and it's on an interesting topic that's being discussed in India quite a bit of late. When you seek an anti-arbitration injunction, and there are several common law courts, India, UK, Australia, Singapore, that may possess the jurisdiction to grant such an injunction, what factors would you consider in choosing which court to approach for the injunction? Given that Indian courts do not easily grant damages for injunctions that should not have been granted, would you be likelier to approach Indian courts for the injunction?
Okay, again, let's break this up into two aspects, right? I mean, because let's leave the damages part out of it for a moment, and let's look at it from the perspective of which court. The standard that is applied in every court is one that there must be exceptional circumstances. That's the legal threshold for granting an anti-arbitration injunction. Now, if I was to look at if all things were equal, I would honestly look at case law and say there is not a single case in India where an anti-arbitration injunction has been successfully granted all the way to the highest court. At some point, it's always been vacated. So history of jurisprudence in India doesn't really make it the best court to try and get an anti-arbitration injunction. On the other hand, I mean, if I look at English law, I have 7 cases where the English court has in a foreign seated arbitration granted an anti-arbitration injunction. Now, the reason why I know this is because during COVID-19, I did one case before the Delhi High Court where we asked for an anti-arbitration injunction, knowing fully well that the odds were against us because the arbitration was seated in London. But guess what? This is where practical realities come in. We made out a case. The other side was called upon to respond to that case. And just around that time, we made a proposal. And we said, we have absolutely no problem if the counterparty does not proceed with the arbitration that's commenced in London, but agrees to arbitration in New Delhi. And those via media solutions very often appeal to a judge, because at the end of the day, a judge takes the view that if I can find a solution, then I'd rather find a solution. And this is the difference between, say, just a black letter judge who perhaps in a different court system would say, sorry, I'm not here trying to find a solution. You either make out a case or you don't make out a case. And an Indian judge who is very equity minded, who is very judicially minded. And I'm not saying the other judges are not. Of course they are, but they follow a slightly different principled contractual approach. And the Indian judge says, if I can find a solution, it is my duty to help the parties. So the judge called upon the other side and said, why don't you take instructions? Because frankly, we have a great solution on the table. And half an hour later, the counterparty came back and said, yes, we agree to arbitration in India. And it was a successful anti-arbitration injunction because we got the London proceedings stopped, and by consent, we moved to proceedings in India.
So if you don't mind, can I ask you another question?
Sure.
Yeah. We've got an interesting question about attorney-client privileges because they vary across jurisdictions and how that might affect the kind of approach that you take in proceedings.
Okay, so I'm going to take this a step beyond attorney-client privilege because it's important for you to understand the doctrine of privilege. When I look at Indian law, yes, there is attorney-client privilege. And things that a client may say to me would necessarily be privileged, or say to any other lawyer. But there's a concept called litigation privilege, which does not exist in India, where even if clients have written things to each other and communicated with each other in relation to a litigation, and very often you actually have to do that because two departments of a company are writing about a litigation that's been filed against them, and they're taking positions. Well, that is protected by something called litigation privilege. Now, if you are in a jurisdiction which protects and has a carve-out for litigation privilege, then you are significantly covered if your communication, even intra-parties, without an attorney, bears in mind that you're creating certain correspondence, documents, reports from the perspective of litigation, and that would be privileged. But if that jurisdiction does not have litigation privilege, then the way you approach this is very simple. Just loop your lawyer into practically everything that you're going to do once you know that a litigation is going to arise or that it's been commenced. So if there is a dispute in relation to the quality of something that you have manufactured, and you are getting an internal investigation done for your own self because you need to defend your case, well, copy a lawyer in, because if their report is bad, it's privileged. That's the key.
All right. With that, I think we'll conclude this session, sir. Thank you very much for taking time out and giving us this lecture, and for really enlivening the lecture with all those wonderful examples that you gave us. Thank you once again. And thank you everyone who joined us both on Zoom and on YouTube for attending this lecture today. Thank you.
No, thank you so much. And sorry for that little blip